How do you analyze a diversity jurisdiction issue on a civil procedure essay? Well, step one, you have to understand what subject matter jurisdiction is. So if you don't know what subject matter jurisdiction is, go ahead and pause the video, go back, watch my video on subject matter jurisdiction, and then resume watching this video. But remember, in short, subject matter jurisdiction is merely a requirement that a federal court must have to have the authority to hear and decide a case before it. And remember, I like to say that there are 4 ways a federal court can obtain subject matter jurisdiction. Number 1, federal question jurisdiction. Number 2, diversity jurisdiction. Number 3, supplemental jurisdiction. And number 4, removal. Now, obviously, number 1 and 2, federal question jurisdiction and diversity jurisdiction, are going to be the main 2 that you want to think about, especially in a civil procedure essay. When you're in the middle of a subject matter jurisdiction analysis, federal question and diversity are probably going to be the first 2 you want to think about and discuss on your essay. But you don't want to forget about supplemental jurisdiction and removal. So we'll go ahead and come back to these guys in future videos. Right now, let's just focus on diversity jurisdiction. So how does a federal court obtain subject matter jurisdiction under diversity jurisdiction? Right? So for diversity jurisdiction, in order for a federal court to have diversity jurisdiction over a lawsuit, you're going to have 2 requirements. Number 1, there has to be complete diversity between the parties. And number 2, you're going to have the amount in controversy, or AIC, exceed $75,000. Okay, so pretty simple. If both of these requirements are met, if you have complete diversity between the parties and the amount in controversy exceeds $75,000, then that court is going to have subject matter jurisdiction over the case under diversity jurisdiction. But let's go ahead and break down this first requirement first, and then we'll come back to the amount in controversy requirement. So what is complete diversity? Well, if every citizenship represented on the plaintiff side of the case is different from every citizenship represented on the defendant side of the case, then you have complete diversity. So let's take a really, really easy example. Say you have a plaintiff suing a defendant. Pretty straightforward lawsuit. Now let's say the plaintiff is a citizen of the state of New York. And let's say the defendant is a citizen of the state of Texas. Is there complete diversity? The answer here is yes. If you look at the citizenship represented on the plaintiff side of the case and every citizenship represented on the defendant side of the case, they are different. So we have complete diversity. Now, of course, I can change this up very easily. Let's say that the defendant is also from New York. Say the defendant is also from New York. What happens to complete diversity in this scenario? Is every citizenship represented on the plaintiff side of the case different from every citizenship represented on the defendant side of the case? Here, the answer is obviously going to be no. They're both from New York, so we don't have complete diversity, so we can't have diversity jurisdiction. This destroys complete diversity. Now, on a civil procedure essay, it's probably never going to be that easy. The first thing that's going to happen to complicate matters is there's probably going to be multiple parties. So let's say you have 3 plaintiffs. Plaintiff 1, plaintiff 2, plaintiff 3, suing 2 defendants. Defendant 1, defendant 2. Okay? And let's say that the plaintiffs are from, well, let's say plaintiff 1 is from Texas, let's say plaintiff 2 is from Texas, and let's say plaintiff 3 is from Florida, and let's say both the defendants are citizens of New York. So here we have a plaintiff, 2 plaintiffs who are citizens of Texas, and 1 plaintiff who's a citizen of Florida suing 2 citizens of New York. So what happens? Do we have complete diversity here? Well, is every citizenship represented on the plaintiff side of the case different from every citizenship represented on the defendant side of the case? Let's go ahead and draw some lines here between the V and compare. Texas, Texas, Florida, New York, New York. Yes, complete diversity is present. Every citizenship represented on the plaintiff side of the case is different from every citizenship represented on the defendant side of the case. It doesn't matter that two plaintiffs share citizenship and two defendants share citizenship. We're only making the comparison across the V when we're making this determination. So obviously, if we wanted to destroy complete diversity, what would we make defendant 2 a citizen of? Well, if defendant 2 is a citizen of Texas or Florida, either one of those, now complete diversity is destroyed, because whether defendant 2 is a citizen of Texas or Florida, now every citizenship represented on the plaintiff side of the case is not different than every citizenship represented on the defendant side of the case. So complete diversity is now going to be destroyed. Okay, so all of this is very straightforward, very easy. On a civil procedure essay, this is exactly what you want to do. In the margins, as you're reading the fact pattern, draw this diagram up. Every single plaintiff, add a V, put every single defendant, and put where each one is a citizen, and look at both sides of the V and see if you have any matches. If any match on both sides of the V, then you can't have complete diversity. But all of this begs a big question, right? There should be a question burning in your head right now. As all the future lawyers I know you are, inquisitive lawyers you're all going to be, this begs a question, right? How do we determine citizenship for diversity purposes? What is citizenship? You know, obviously you hear people all the time say that they have dual citizenship. Someone can have a passport in the US and Canada at the same time and they call themselves a dual citizen. Forget all of that stuff. For diversity jurisdiction purposes, these are the rules and you want to follow these. It's important to remember this. So the rules are going to vary slightly depending on the type of party involved in the action. So the main two you're going to see are individuals and corporations. And the rules for determining citizenship are going to be different for individuals and corporations. The main thing that you have to realize, number one, is an individual is the citizen in the state or country in which the individual is domiciled. So what is domicile? Your domicile is the state or country where you reside with an intent to remain indefinitely. It's where you live, right? And what's important to recognize here again is you can only have one domicile for diversity purposes. So it doesn't matter if I have a vacation home in New York but I live primarily, I reside in Florida with an intent to remain indefinitely. The vacation home doesn't matter. Where do you reside with an intent to remain indefinitely? And remember, you can only have one domicile. An individual cannot be a citizen for diversity purposes in two states or two countries at one time. You can only have one domicile. Very important to recognize. An individual, say it one more time, can only be a citizen of one state or one country for the purposes of determining citizenship for diversity. Okay? Corporations, on the other hand, hold dual citizenship. Very different. A corporation is going to be a citizen of two different places. Okay? The state or country where its principal place of business is located. Principal place of business. And the state or country where the corporation is incorporated. This is where they file their articles of incorporation. So you're going to have, for a corporation, for citizenship, for purposes of diversity jurisdiction, they have two states, two countries of citizenship. So Number one, you're going to have the principal place of business. This is simply where the headquarters are located. In civil procedure, you'll hear this referred to as the nerve center test. Basically, all that means is where are the headquarters stationed? Where are the headquarters located? That's the principal place of business, and that's going to count as one place of citizenship. Incorporation is where are they filing the articles of incorporation. When that company was first formed, where did they file their articles of incorporation? Typically, on a civil procedure essay, you're going to see that as Delaware. Oftentimes, this is true in real life too. Companies want to take advantage of the Delaware court systems and maybe some tax benefits that are offered in Delaware. So they actually incorporate in Delaware, even though they run no business out of Delaware. They could have their headquarters, principal place of business in New York, but they filed in Delaware to get access to different tax breaks and business benefits, okay? So you would then, that corporation would be a citizen of both New York, where it's headquartered, and Delaware at the same time, where it's incorporated, okay? So let's draw this out. One more example, and we'll tie this all together, okay? Hopefully this will make sense. Okay, so let's take an individual, let's name him Jones. Jones is suing a corporation. Let's call the corporation Acme LLC. Okay, so we clearly have an individual suing a corporation. So we have to first determine where their citizen, if we're doing a complete diversity analysis. Step one, where is each party a citizen? Okay, so Jones, what's the test, right? Where is Jones domiciled? Where is Jones' place of residence where he has an intent to remain indefinitely? Let's say Jones lives in the state of Texas, okay? Very straightforward. He has his house in Texas. He plans to remain there indefinitely. He's domiciled, is in Texas, so Jones is a citizen of Texas. Now let's say that Acme LLC, like we discussed earlier, they're clever. They want to take advantage of the Delaware business court system, so they file their articles of incorporation in Delaware. So they're a citizen of Delaware. But remember, a corporation holds dual citizenship. So they're also going to be a citizen where the principal place of business is located. So we have to determine where Acme LLC's nerve center is. Where are their headquarters located? Let's say Acme LLC is a tech startup. Austin, Texas is becoming a new tech center, kind of like Silicon Valley. Let's say that they have their principal place of business in Texas. That's where they're headquartered. Okay, so does complete diversity exist? Well, does every citizenship on the plaintiff side of the case, is every citizenship on the plaintiff side of the case different than every citizenship on the defendant side of the case? Well, we got Texas and Delaware, so that's diverse, but we also have Texas and Texas. So right here, complete diversity is destroyed. The analysis is over. Diversity jurisdiction cannot exist between Jones and Acme. Okay, it doesn't matter that Texas and Delaware are diverse. Corporations hold dual citizenship. Now, obviously, if Acme LLC was headquartered in New York, say that they're headquartered in New York now, again, we have complete diversity. Every citizenship represented on the plaintiff side of the case is different than every citizenship represented on the defendant side of the case. Very straightforward stuff. Remember, number one, when you're going through the first requirement and determining complete diversity, remember, first step, you have to determine the citizenship of each party. Second step, do your diagram, compare both sides of the V. Is every citizenship on the plaintiff side different than every citizenship on the defendant side? If so, you have complete diversity. You move on to the second requirement. If not, complete diversity can't exist. But you still want to move on to the second requirement, obviously on a civil procedure essay, to rack up the most possible points. So either way, you would move on to your second requirement, which is, remember, diversity jurisdiction exists if complete diversity exists between the parties, and number two, the amount in controversy exceeds $75,000. $75,000. Okay, so what is the AIC, amount in controversy? The amount in controversy is simply the monetary value that's at stake in a lawsuit. This is generally going to be very straightforward. Say that there's a car accident. The plaintiff is suing the defendant for standard negligence. Say that the plaintiff suffered injury, had to go to the hospital, had $100,000 in medical bills. So is suing the defendant to recover their medical bills, and that's again for $100,000. The monetary value at stake in the lawsuit is $100,000. We call that the amount in controversy. So in that case, the amount in controversy exceeds $75,000. Very straightforward. The second requirement is met. You can sum that up in one sentence, and oftentimes it could be that simple, even on a civil procedure essay. The monetary value at stake, the only way that actually determining what the monetary value is could get complicated is in a situation where the plaintiff is seeking equitable remedies. Now, this is pretty rare, but I have seen it come up. Basically, if the plaintiff is seeking an injunction, right, not suing for monetary damages, suing for equitable remedies of some kind, generally you're going to see it as an injunction. What you can do is take the benefit to the plaintiff or the cost of compliance to the defendant, extrapolate that dollar amount, and that's your amount in controversy. But that's going to have to be in the fact pattern. The fact pattern has to give you a dollar amount that you can extrapolate. So even if they're seeking equitable remedies, look for the dollar amounts to determine what the amount in controversy is, the monetary value at stake in the lawsuit. Okay, so where can the amount in controversy requirement get complicated? Usually, like I said, it can be pretty straightforward, but the main way that this gets complicated is when you have multiple claims. So again, let's say you have a plaintiff suing a defendant on two separate claims. Number one, we'll say it's a $50,000 claim, and number two, we'll say it's a $30,000 claim. Okay, let's stick with the car accident here. It's a negligence action. Two claims. The first claim, let's say, is medical bills. Same idea. You suffer injury, you want to recover your medical bills, so you file suit for $50,000. Let's say that you're also, I don't know, what could happen here? Lost wages, right? So you've had $50,000 in medical bills, and you also have $30,000 in lost wages. You're in the hospital for a few months, you can't work, you're on leave, you don't get paid, so you lose $30,000 in income. You file that as a separate claim. So you file two claims against the defendant. Okay, one for $50,000, one for $30,000. Now you'll notice here, the amount in controversy requirement has to exceed $75,000. Sorry, let me just fix this. So neither one of these claims independently satisfies the amount in controversy requirement. $50,000 is less than $75,000. $30,000 is less than $75,000. So the question then becomes, can we aggregate these claims, the $50,000 claim and the $30,000 claim, to get to $80,000 to exceed $75,000? And the answer here is going to be yes. If you have one plaintiff suing one defendant, generally you're going to be able to aggregate the claims. Now, where this can get a little bit nuanced is, imagine this situation. Say that you have a plaintiff suing two defendants on two different claims. So you have defendant 1 and defendant 2, and plaintiff is firing off claims separately against both of these. Sorry about that, we just had a small accident in the office. Everyone seems to be okay. So again, though, say that we have two claims against two defendants. So the first one, let's stick to the same numbers, is $50,000, and your second claim is $30,000. Okay, again, same idea, very simple. Neither of these independently satisfies the amount in controversy. $50,000 is less than $75,000, $30,000 is less than $75,000. The question is, can we aggregate them to $80,000 to get over the $75,000 hump? And the answer is going to be when you have multiple defendants, you're allowed to aggregate the claims if the defendants are jointly liable. If the defendants are jointly liable, then you can aggregate these. If the defendants are not jointly liable, it's independent claims, independent liability, you're not going to be able to aggregate the claims. Very straightforward stuff, guys. The last combination, I'm sure many of you can guess where this is going. The last combination you're going to see here would be obviously if you have multiple plaintiffs, right? You have multiple plaintiffs, say it's one defendant, and you got two claims, one for $50,000, one for $30,000. Again, neither one of these claims satisfies the amount in controversy requirement independently. The question is, can we aggregate them? If you got more than one plaintiff, the answer is generally going to be no. Each plaintiff's claim is going to have to satisfy the amount in controversy requirement separately, unless there's one gigantic caveat to this situation right here. Unless, generally you can't aggregate these unless supplemental jurisdiction applies. Remember at the very beginning of this video I said that there was 4 ways that a federal court could obtain subject matter jurisdiction. Number 1 was federal question jurisdiction. Number 2 was diversity jurisdiction. Number 3 is right here, supplemental jurisdiction, and it's this exact situation. When this happens, the answer is generally going to be no. The plaintiff can't aggregate those claims. The plaintiffs can't aggregate those claims to get over the $75,000 mark unless supplemental jurisdiction applies. So just hold on for now because supplemental jurisdiction warrants a whole new video. I'll go into that in our next video. So stay tuned if you want to see how this situation plays out with the common nucleus of operative fact and same transaction or occurrence. Is exciting stuff. Hold off until the next video and I'll explain to you how that situation would play out. But let's just recap diversity jurisdiction because we basically talked about every main issue that you could see pop up on a diversity jurisdiction analysis. Remember the requirements for a federal court to obtain subject matter jurisdiction under diversity jurisdiction. Again, one last time. Number 1, you have to have complete diversity between the parties. And number 2, the amount in controversy has to exceed $75,000.